should the court override the spouse's separation agreement due to post-signing events. In this particular case, the spouses have been together 26 years and married for 18 of those. Their own separation agreement provided that the husband, 1, waived all claims to spousal support, 2, released his interest in the matrimonial home, and 3, assumed responsibility for a greater share of the debt and he and the wife had accumulated during the course of the marriage. In exchange, the husband would be absolved of all financial responsibilities for child support for their 2 children. Although the agreement was struck with the aid of a lawyer, the husband helped choose the lawyer and had no independent legal advice prior to signing, even though he had a choice. He was unemployed at the time, even though he was a trained investment advisor who had previously earned a very good money during his career. Within a year of signing, the still unemployed husband stopped paying off all the joint debts that he had agreed to assume. His registration with the Investment Dealers Association of Canada was suspended, and he had no place to live. He slept on the floor of a stockroom and at the homes of his sister and parents. The husband commenced a court application against the wife. He challenged the validity of the entire separation agreement and asked for lump sum spousal support, notwithstanding the support waiver he had just signed. A lower court found that there was no basis for setting aside the entire agreement, but agreed that in the circumstances, the husband should get lump sum support from the wife and awarded him $144,000. On a subsequent appeal, the Ontario Court of Appeal confirmed the lower court ruling. The court reasoned that in this scenario, there was 2 potential sources of the court's authority for making an order that was requested. The first was the Provincial Family Law Act, which deals with the intrinsic flaws as in how a domestic contract is formed, and allows the court to set it aside in some circumstances. However, the husband had not proven he had met any of the relevant tests for doing so here. The separation agreement was not unconscionable, and it could not be said that the husband did not understand its nature and consequence. The Court of Appeal also noted that the husband's idea to hire a lawyer, it was the husband's idea to hire a lawyer and draft it, and that he could have obtained independent legal advice if he wished. On the other hand, the court circumvented the spousal support waiver under the second source of its authority, the court's powers under the Divorce Act, which allows it to override an agreement or clause that does not substantially or substantially comply with the objectives of that legislation. Using a detailed 2-part test from a case called Milgan, especially in light of the husband's current unemployment and other misfortunes, which the lower court seemed to conclude were at least partly marriage-related, the separation agreement could be validly overridden in this scenario. The Court of Appeal had no reason to interfere with the lower court's fact-based assessment and left the lump sum award at $144,000 untouched. What do you think? Do you think the court got this decision right? You can give this video a thumbs up, comment below, and share it with your friends and family. You can subscribe to get up-to-date family law videos that we produce, such as A Day in the Life of a Family Lawyer, as well as other Q&A videos that we're working on. Be sure to subscribe and hit the bell icon, and you'll get notice of when we post our new videos. Thank you for watching today. I'm Russell Alexander.